Did you know that there are over 160,000 registered charities, with about 5,000 new charities being registered every year? Now, you might think, well, that's fine, the more charities there are, the better. But over the last few decades, charities have been under increasing pressure to merge so that they more effectively pursue their objectives. Why have two charities looking for a cure for cancer, let's say, working in the same area, in the same geographical area, looking at the same kind of cancer, when they could probably pool their resources and work more effectively? You may say that would be a good idea. One of the things that's deterred charities from merging over the years, it's only one of them admittedly, is the legal process that would have to be undertaken to enable that merger to take place. Charities have been particularly concerned about losing funds as a result of a merger. If you think about it, what happens if you make a donation, possibly in your will, that comes into effect many years in the future, to a charity that no longer exists because it was already merged with another one in the interim years between you making your gift and the gift coming into effect? That's just one problem that could arise. So a couple of years, well, quite a few years ago now, myself and my colleagues in the Charity Law and Policy Unit were funded by the ESRC to look at the legal problems that charity mergers cause. And we found a number of particular problems, things like, as I said, the concern about the transfer of assets to merged charities, the possibility that assets would be lost, mergers failing because of lack of due diligence. Just like with businesses that merge, there's a lot of activity that needs to be undertaken in advance to make sure that this is the right marriage, effectively, for two organisations. They may be looking at the same issue, but they may have very different ethoses as to the way they work. They may be governed in very different ways, so due diligence is very important. The processes for legal merger were complex and lengthy. What we did with our research, we produced a number of outputs, so a report outlining the problems with some suggested solutions, and also a legal good practice guide to charity mergers. And this has become a very useful resource for charities considering merger. Our research concluded that the legal challenges of merger could best be met by the introduction of new legal mechanisms for merger. And we were delighted when these recommendations were ultimately adopted in legislation, which you can now find in the Charities Act 2011, Part 16. The new legal framework for mergers, for example, creates for the first time a register of charity mergers to enhance and manage assets on mergers, so you can actually look and see that organisation that used to exist. What is it part of now? What's the new name of the organisation? When did the merger take place? What's happened to the pre-existing organisations? Did they merge into one, or did they create a completely new entity? The framework also provides a statutory definition of a relevant merger, so we know what is governed by the new legislation, and it all helps to smooth the process. In relation to our recommendations around due diligence before engaging with this new statutory framework, well, again, we're pleased to say that these have been adopted in sector guidance publications, for example, Charity Commission guidance on mergers, and these have been referred to frequently. Mergers of organisations have increased as part of a wider drive to provide an effective charity sector, and we would like to think that this has been facilitated by the reformed legal process. And it's interesting, if you look at the register of charity mergers, you can now see over 1,900 registered mergers of charities that have been completed.